Hi guys, bienvenue sur ma chaîne. This is Batok with Ola Ijesuizola. Thank you so much for stopping by once again. Today we want to talk about adopting a final written address in a civil matter. Yes, I know I've done a video on that before, but you would recall that we did that talking about a criminal matter. Someone then asked the question, what about a civil matter? How do you adopt your final written address? The thing is, they are basically the same, but it does not hurt anyone for us to go over it again. So let's do just that. Now, what's a final written address? A final written address is the final address of both parties in a matter. In the civil matter that we're using as an example today, this is how civil matters proceed, okay? When the matter has been filed by the claimant and the defendant has been served and both parties have entered appearance, and they will go through PTC for cases where PTC is applicable. I have a video on PTC, that's pre-trial conference. Please watch it. I'll link it in the description box. And after all that, after the matter has been set down for trial will begin, and then the claimant will open their own case by calling their witnesses, CW1, CW2, and so on and so on, and then they would close their case, and then the defense will also open their own case, DW1, DW2, and so on. They'll call their witnesses, they'll tender the documents they want to tender, and then close their case. When both parties have now closed their case, the court will now ask them when it will be convenient for them to file their written address. According to the court rules, written address is supposed to be filed 21 days, within 21 days. So the court will ask, do you want to file 21 days? And then the party that closes its case last is the first to file a final written address. Yeah, and then the other party would also file theirs. So usually the court will say, okay, 21 days, let's count it concurrently. So 42 days for both of you. So you file your written address, both of you, within those 42 court days. So because you cannot count days that court is not sitting, so the court will ask you to count. You count it in open court. The registrar would also, assist in doing that. So you just count, 42 court days, excluding Saturdays and Sundays, of course. And then the court would expect that both of you will come back to court to adopt the written addresses that you have filed after 42 days, well after 42 days. And after you have come to adopt it, then the court will now give you a date for judgment. And usually judgment is within 90 days from the adoption of final written address. So that's the procedure. Now, what's a final written address? A final written address is your final argument in the matter. That is, in that final written address, you have the ample opportunity to make your case before the court. That, okay, you can see, my lord, that during the evidence given or during the trial, if you are the defendant now, the claimant did this, they said this, they said that, or it couldn't have been so. This means that they are lying. Witness A said this, witness B said this, they contradicted each other. My lord, in this decided case, the court held that so and so and so. That's similar to our case. My lord, in that other case, you distinguish cases, you look for similarities in cases. You cite cases, basically, cite textbooks, authors, judicial precedents, and, all manner of things. You basically put a case together. So after you have already done trial where you've given evidence, written address, final written address is the opportunity for you to address every other thing that's been said or that has not been said, and to address everything that has not yet been addressed and everything that's been addressed. It's like the last leg you're putting forward in the case. So it's got to be the best leg. In the past, in Nigeria, and I'm sure in other jurisdictions, people used to give final written address orally. Yeah, and so that was the opportunity that people in the past had, to shine as lawyers. It was an opportunity for lawyers to shine, because that is when we really know your worth. That's where you really get to defend your client and speak for your client. You know that earlier in the case, you have been bringing witnesses, bringing your own client to speak for themselves. So final written address is where you do your job as a lawyer. It's where you shine as a lawyer. That's when we know brilliant lawyers. But these days, it is written, not oral. So it is still a test of brilliance and intelligence, the intelligence of the lawyer, but now only the judge would read it and then decide based on both written addresses who to give judgment in favor of and who to give judgment against. So it's a very important and crucial part. You cannot miss it, whether you are the claimant or the defendant in a civil matter. That is like your final shot, to get what you want from the court. And if you do well enough and the judge is so persuaded, he will grant judgment in your favor and against your opponent. So that's what a final written address is. And even these days, there are some matters that maybe a party is raising an objection or another party is saying, no, it shouldn't be this, it shouldn't be that. The court will say, please, that's a matter for address. So sometimes the court will tell you there are some petty matters that come along the way during trial. The court will tell you that, okay, put that in your final written address, address that during your final written address. And even there are some courts now that say that, okay, even when you make certain applications or raise certain objections during the trial, they will give the ruling on that alongside the judgment when the final written address has also been considered. So a final written address is very important, and it's called final written address because it is written now, no longer oral. You know, we talk about lawyers like Chief Sapara Williams in Nigeria, lawyers like Gani Fawemi, you know, all those lawyers. Some of them shined the most during the final address that was given orally in those days. But now it is written. And so it's important, you know, for a lawyer to bring their A game in preparing the final written address. And then when it's been filed and exchanged, because the party that closes its case last, which is usually the defendant, will file first and serve the claimant. So the claimant will now prepare their own based on what the defendant has filed. And then they would also serve the defendant and file it in court. So that means that they both exchanged written addresses and filed it at the same time. So after that has been done, they will both now come to court to adopt it. Adoption just means that you're coming to court to tell the court that what we have filed, you know, we want you to now consider it and decide for us. It's the same way, you know, we front load our documents, but even after front loading documents, you still need to tender it in court, adopt it in evidence. If not, the court will not consider it. So that's the same way it is with a final written address. After filing it, you have to come to court to adopt it. That is to tell the court, this is my final argument in this matter. Now, look at it and decide for me. And this other person will say the same thing. So after 42 days have been counted, which is 21 days for both parties, you can now come back to court and then adopt it. So how do you adopt a final written address? On the day that the matter is slated for adoption of final written address, you come to court. So when your case is called, the court will ask you, why are we here today? And then you should be familiar with that if you've watched all the videos that I've done, you know, on, courtroom drama or litigation or how things go on in court. So, or examination in chief, whatever. So the court will ask, why are we here today? And then you get my lord, we are here for, the matter is slated today for adoption of final written address. Then the court will ask you, are you ready? Yes. The court will ask the other party, are you ready? Yes. If both of you are ready, then the court will ask you to go on. So you tell the court, I'm assuming that you're the claimant now. My lord, the claimant has filed his final written address in this matter. Our final written address is dated the 22nd of August 2022 and filed on the same day. And then the court will ask if the other party has been served. Then you say, yes, my lord. Then they will confirm that they've been, you say yes, and then they will confirm that, yes, my lord, we've been served. Because, you know, both of you have to have exchanged final written address. And then, or if you are the later party, the court will ask the person that is speaking if they've served you, and then you will confirm that you've been served. And then you go on. It's dated 22nd August 2022 and filed on the same date. The court will ask about the exchange and all of that. And then you tell the court, my lord, we'll be relying on all the arguments in our final written address. And we seek to adopt same as our case for the claimant in this matter. If you're the defendant too, same thing. My lord, the defense has filed a final written address dated 30th August 2022 and filed on the same date. My lord, we have served the claimant. Then the court will confirm that, and then you tell the court, that my lord, we seek to rely on all the arguments in our written address. My lord, we'll be relying on all the arguments in the written address, and we seek to adopt same as the case of the claimant or as the case of the defendant in this matter. We urge my lord to grant judgment in our favor and against the claimant. Or we urge my Lord to grant judgment in our favor and against the defendant. We're most grateful, my Lord. So that is how to adopt your final written address. Because our address is no longer oral in our Nigerian judicial system, you need not say anything further. In some instances, it will be that a senior will just send you as the junior that just go and adopt our final written address. I don't want to go to court today. So you need not say anything further. If that's the case, just sit down. But if you are well abreast of the matter, if you are very much involved in the matter and you know what is in the written address, or if you're actually the one that is handling the matter, whether you're a senior or a junior, you can choose to adumbrate. Adumbration just means that you want to say some other things and emphasize some of your key points in your arguments. So some courts will allow it, some courts will tell you to sit down. That is already included in your written address. So the court will go and read it. No need to waste the time of the court. But usually the court will indulge a senior lawyer, maybe an SAN or a very senior lawyer, or a lawyer that's well known to the court, because those ones, they like to talk. So the court might indulge them in adumbration. And even if you're a junior lawyer, you know, the judge might just like you, or like your face, and allow you to adumbrate. But in most cases, most judges will just say, once your arguments are already contained in your written address, there's no need for you to talk further. Let's just move on. So if you want to adumbrate, we now begin to analyze or emphasize the important points. My Lord, we formulated a sole, issue for determination in this, in our final written address, and that is whether from the totality of the evidence laid by the claimant in this matter, the claimant is entitled to all the claims sought before this court. My Lord, in his paragraph the claimant argued that they are entitled to so and so and so, because he who asserts must prove, my Lord. My Lord, the defendant during the trial refused to give any evidence linking our claimant, linking the claimant to any of the allegations, that they made against her. My Lord, the defense also failed to prove so and so and so and so, My Lord, if you look at the conduct of the defendant throughout this suit, my Lord, it was one of nonchalance and arrogance towards the court. My Lord, the defense has given the claimant the middle finger, and by extension, asking to see what this court will do. It is our hope, and we surely and firmly believe in the court's duty and ability to do justice in this matter. My Lord, in the case of so and so and so and so, this was how the defendant was also. But the court held for the claimant because so and so and so. So you just continue to, defend yourself. I'm speaking for the claimant now, so you can see that. Just begin to tell the court some of the things that you've raised in your written address and why it is so, also tackling, the defendant. And that's because, you've exchanged written address, so you already know what is in their own. You can even say that, oh, my Lord, the defendant has claimed in their own written address that the claimant is just on a wild goose chase. We believe that this honorable court will prove them will prove that. We believe that this honorable court will prove that to be otherwise. And we have, furnished, my Lord, with a plethora of decided cases in support of our claims before this court. My Lord, in the case of so and so and so, the Supreme Court held that so is the case. My Lord, in the case of so and so and so, your learned brothers at the Supreme Court also held that so and so is the case, my Lord. Our case is not different. It is similar, and we implore your Lordship to consider, to consider these cases, and grant judgment in our favor. My Lord, the claimant firmly believes in these courts. So, you just keep talking, you gas my Lord up as well as you're citing decided cases and talking about, what you want and how you believe that the court will do justice, and how, what they have said in their own case is not true, and the parts where you have attacked it in your own address, just point my Lord to it. Sometimes the court might take some notes, so that when he's making his decision much later, he can refer to it. Sometimes he will just watch you. But don't ever make the mistake of thinking that even when the court is not writing, that you are not on record. Because even when the court is not writing, Milord is a human being. So he's listening to everything you're saying. When it's time for him to give judgment or to write his judgment, he will remember your conduct. He will remember your tone. He will remember your mien. He will remember your countenance. He will remember the examples that you gave. So if you want to adumbrate, by all means adumbrate. And I hope that you always get whatever you want from the court, as long as it is fair and just. So that is how to adopt a final written address in a Nigerian court. I hope that it is very clear, and I hope that you will be able to try this on your own and do it successfully. That's all I have for you in this video. Don't forget to subscribe, please. And I have a link to an article that I wrote about mediation, my mediation experience so far, in the description box. I'd love for you to read it. Thank you. Toodles.